Don't let a piece of paper, or a lack thereof, determine your family's future. Did you know that without having a plan in place, the state can end up deciding who raises your children, who gets your house, or how long it takes for your loved ones to get anything upon your passing? That fear of the unknown, or the unwillingness to take the time to go through this documentation, is what stops most from ever starting. Today, we're cutting through the complexity with attorney Lisa Solbakken, partner at Arkin Solbakken LLP, frequently recognized as a New York State super lawyer, to help us talk to you about the basics of estate planning.
Hey, good afternoon, Lisa. It's great having you here, and thank you very much for your time. This topic, estate planning, is something that we speak about on a constant basis with clients and prospects, and just wanted to get some insight from you today. So I figured I'd start with the first question. What do you feel is the number one mistake that can cost families the most money or the most stress?
Thank you very much, Gabriel. Very happy to be here. Part of my objective today is going to be to demystify some of this process. So, in answer to your first question, which is a very good one, we see sort of two primary things that lead to a fair amount of value loss. That is having no estate planning at all, or having estate planning that is out of date, either because it no longer matches your asset portfolio or it is no longer compliant with applicable law. And in either one of those cases, what is going to happen is there's going to be an elongated probate process, which we can talk a little bit more about in a bit, a ton of uncertainty for your loved ones and for your beneficiaries, and value leakage because of attorney's costs, fees, and various other things that are going to occur because when you're in probate, you lose control over the process, and you can no longer influence as much of the outcome as you otherwise would be able to handle.
Thank you. What would you say the main difference is when planning for legacy versus planning for incapacity?
Okay. So both are very laudable and important objectives, but they're very different, right? So legacy is what you're trying to set up in connection with the benefactor's passing. Who are my assets going to go to? What trusts are going to be triggered, and what's going to happen from there? Incapacity, equally important to prepare for, but fundamentally different, can occur through physical disability, cognitive decline. It can be temporary, it can be permanent. And in those instances, you're going to need somebody who you trust to be running the ship. And what that means is you need somebody you trust to be making financial decisions, legal decisions, and in some instances, medical decisions. And there's various ways that you can do that through whether it's a revocable living trust or it's through healthcare directives or a living will. But there's various documents and ways that your attorney can sort of help you plan for incapacity.
Thank you.
Sure.
Okay, so talk to me about probate. What is probate and why do we want to avoid
Probate, for lack of a better word, is court. Probate is paying somebody to show up, paying your money that you want to be bequeathing to your beneficiaries and your family and your friends and your loved ones, and giving that to a lawyer to show up to talk to a judge. It can take anywhere from 9 months to almost 2 years, right? Depending on what's there. It is expensive and it is time consuming. And the best way to avoid it is, and it's completely feasible to do, is by thoughtful planning.
it? Wow, sounds like a disaster.
It can be a disaster, and I'm sure everybody's heard a story or two of some poor family that's been stuck in probate, and by the time that they're done with it, the estate is essentially gone. Yeah,
Gotta prepare. Gotta
yeah,
prepare. So let me ask you this then.
sure.
What is a will and what does it do and not do?
Right. So, when we talk about planning and careful planning, let's start with, and this is sort of the demystifying of the process that I mentioned to you earlier. What is a will? A will is a pretty basic document. It is the document that you can send your assets through, and you can designate beneficiaries and whatnot. You name an executor, you can name a guardian, you can name a trustee. Um, at the same time, it is not always the most efficient way to proceed in connection with estate planning, right? Because everything there is going to be subject to recovery from creditors and subject to taxes, and all things of that like. So, you can never really get away from having a will. You have to have it, something that's called a pour over will, to the extent that you do decide to put all of your assets into a trust, which is something that we tend to recommend. You're always going to have one, but having a will alone is not always the best way to go.
Hmm. So, what is a durable POA, shifting gears here, and how can it play an essential role in one's planning over time?
Right. So a durable POA, durable power of attorney, is one of the tools, sort of like a living will, that in at points of incapacity, you're going to want to have in place. So a durable POA is going to allow somebody to come in and to manage your accounts. They're going to be able to pay your mortgage. They're going to make sure that your insurance doesn't lapse. All of the boring sort of day-to-day things that are critical to us when we're incapacitated is going to be handled by that person who you appoint, to at least to the extent that you don't, direct somebody else to also be involved. You don't have to have just one person acting on in all manner on your behalf. You have flexibility. But that person is going to be captaining your ship while you are not there to captain it yourself.
Mhm.
And I
Okay.
would say that like sort of directly leads into, all right, well, what is a revocable trust, right? A revocable trust is a great device because it keeps assets out of probate. Whereas if you had your assets distributed just via your will, they will still be subject to some extent to the probate process. So it is far more efficient to have a revocable trust in addition to your will. Um, what does it mean? It means that it's obviously revocable. That's right there in the name. You have it managed by a trustee. But at least the materials that are in the trust, and it can be any manner of asset, are protected from the probate process. Now, your creditors can still attach it, which you may or may not care about. But for the most part, it is the, sort of next step up in estate planning from just having a straightforward will.
Okay. And
And
what about an irrevocable trust?
Yeah, I was just gonna go into that. An irrevocable trust is sort of what I would call more of the Mac Daddy of estate planning. It has an immediate loss of control, which I think is hard for some people, but it has a ton of benefits, right? So once you enter into an irrevocable trust, you cannot change it, ergo the name. However, the assets that are in the irrevocable trust are protected from creditors, and are in many instances protected from taxing, right? Which is a tremendous advantage in the estate planning process. So, the way the law sort of accounts for it is, okay, we're going to make this irrevocable. If you're going to do this, you have to do it. You're not going to be able to take those assets back, right? But but the benefits are tremendous if that's something that you're willing to do. And I've seen, many clients create irrevocable trusts in a way that benefits their children, for example. and putting, some inconsequential, but sometimes more consequential chunks of money in there, to start or foster generational wealth planning.
Thank you. What are some other type of trusts that you might come across that are a bit more common as well?
Right. So the thing about trust is there's so many. And this isn't legal advice. I have to give you that lawyer caveat. The best thing to do is to sit down with a lawyer who understands you, understands your interests, understands your obligations, and what you want to accomplish. But there's all manner of trusts that can be used to assist in estate planning. So there is special needs trusts that you can create. There's revocable charitable remainder trusts, right? Where after a certain allocation, the remainder of your estate can be donated to the charity of your choice. There's all sorts of different things that one can do. I mean, that's just really the tip of the iceberg. We recommend that you sit down and you go through what is important to you with your legal advisor.
Awesome. What would you say, to wrap it up, would be one thing that folks should have on the front of their mind when thinking about this stuff? A lot of times people might be overwhelmed or they don't want to have the conversation because it's kind of tough and weird to think about, maybe end of life or just, giving up control of your assets.
Yep.
Is there any advice that you give for everybody out there when trying to, push forward in this process?
Oof, there's a fair amount to say to that, right? There's the don't be penny wise and pound foolish. There's the 15 minutes of organization is worth, an hour of frantic activity. What I would say is that for a lot of folks, unfortunately, the way that this happens is they realize how important it is a bit too late. Right. So if you're already at a point where, if you're already incapacitated and you don't have these documents in place, game over, right? And there's absolutely no reason to be intimidated by the process. I definitely appreciate the difficulty of looking at, sort of life transition points, right? But this is not, a good lawyer is going to take you through it and help you understand it in a way that is productive and that gives you peace of mind. And I think, most importantly, provide security to your loved ones. I mean, at the end of the day, that's one of the most important things to our clients is, I've worked hard my entire life to provide for my family. Um, you don't want to, at the end of all of that hard work, to leave things to chance, to create a situation where your loved ones don't receive everything to which they're entitled, where your assets, for whatever reason, end up decreasing in value because you didn't engage in the right, beneficiary designation. Um, peace of mind, security for your loved ones, have the talk with a lawyer that you trust and get it done.
Thank you very much.
Sure.
Have
Thank
a
you for
great
having
day.
me. Yeah, you too.